So mandatory authority versus persuasive authority. I used to not really cover this as I thought, well, it's not really a law librarian thing, but it actually comes up a lot when we're talking about just looking at things and looking at cases. Mandatory authority is authority that the court must follow. So it's also called binding authority. So, and that is related to precedent. So we'll talk about precedent in the next slide. Persuasive authority is any authority that, or any kind of writing that, any argument that the court can follow, but it never has to. Or it may not have to. And that differs by jurisdiction. So if something is within the jurisdiction and it's a lower court, then you have to follow it, like a case from the lower court. So you can see in this type of authority, if it's primary, it's a statute, it's constitution, a court decision, or regulation, it's mandatory within that jurisdiction. The highest court has some leeway, but generally they're supposed to follow that authority. So they can't just go out and say, I don't like this rule, I'm going to do a different rule. They have to follow the authority. Now, if I'm in Arkansas and I have a Texas case that I like, but it's Texas, in Arkansas, I can't argue it or bring it in and say this is persuasive. And then how I would bring it in is citing it in a legal document or brief argument. And I would argue that the rule should be the rule as it is in Texas. Now the court may like that argument, so they may be persuaded and they can use it, but only if there is no binding authority that is in line with that. We'll talk about this in a little bit more depth. Secondary, anything that's not primary authority or primary authority within that jurisdiction, it is not going to be mandatory, but it can be persuasive. And we'll talk about that more. I think I'll bring the same slide back in several times where we sort of go back over it after you've had a look at the different resources. So that brings us to precedent and stare decisis. So precedent is the legal doctrine that, I'm just going to read it so I don't get it wrong. So it's going to be any kind of previous ruling that is binding on the lower courts and that is usually followed by the same court. So it's basically the basis of established law that the courts have decided through legal decisions before this one. So there may be a disagreement in the present case. Well, we have to look at the binding authority that was of a similar disagreement. Those will be precedential and we must follow those. So you'll always have attorneys and judges looking for precedent. So you have a set of facts, you look to see what is a precedent, what has been done before on similar circumstances. And if there isn't, always facts are different. If there's a different set of facts, you're going to argue based on other similar set of facts, and that's where the nuances come in, right? Stare decisis is the doctrine behind precedent, and it is the idea that the courts will follow a precedent of the same court or higher courts. If it's of that court, it can be overthrown, but the doctrine is that they will follow what's gone before because for the stability of the law. So the doctrine of stare decisis is what may prevent the court from overturning Roe v. Wade. So you'll hear it talked about in a political theater in the sense of, are the judges committed to stare decisis? Are they going to overthrow a binding authority because circumstances have changed? That's what that means. It's the idea of stability in the law. And it all comes from common law, which is based in England, and it was before there was a sort of parliament to create law. The idea was that these decisions that were being handed down by the judges were developing a set of legal decisions and rules in different cases, in different situations that were going to be held to be used again and again and again. So you have precedents built up, and you always look back to see what has been done before. Another thing, I really like looking at the history about this because it kind of helps explain some of the weirdnesses that developed organically with the law. Initially, the judges didn't have written opinions, so they didn't write their decisions out in writing. They just spoke it. And so there would be people, this was before there were lawyers, there wasn't like a trained set of lawyers. So there would just be people who would write down what happened in the case and summarize it, and then say what the decision of the judge was or what the holding was. And that's the legal part. That's sort of what the nugget of law that came out of the case. And those were developed and sort of published. And these reporters, the people who did this, who wrote these summaries, they would publish these books. So that's how our set of legal cases became known as reporters. Kind of crazy.